can legitimately say it's reasonable because actually we're pointing out that really what should be happening here and what the contracts often say or imply, usually they actually state expressly, is that it's really self-help here from the user's point of view. They're getting a good service, it's much cheaper than they could do in-house. The corollary is users must protect themselves by having backup and or encryption to protect, unauthorized access to their data. So but again, it's slightly odd in that potentially we're going to cloud computers because they're experts in this area of security, etc. But at the same time, they're saying, yeah, we'll hold this for you, we'll keep it safe. But ultimately, we don't want to take responsibility. You need to protect yourself by taking backups and the rest of it. So, in a business sense, I could see it from both sides of the fence, but that's where we are at the moment. Possibly a bit of good news or just something to bear in mind. I mean, there was a recent IT case I thought I'd mention at GB, Gas Holdings and Accenture. This whole issue as to what is direct loss and indirect consequential loss does become important in this context of cloud computing and in commercial contracts generally, because typically, as I've said, there will normally be an amount you can recover, although capped, for direct loss. But for indirect and consequential loss, the normal position is that it's excluded, and up until now, I'm not aware of a case where that has been held to be unreasonable and invalid. The interesting thing about GB Gas Holdings and Accenture is, though, that it was a reminder in an IT setting that a lot of loss that people typically think is a consequence of a breach is not the same as saying it's consequential loss in a legal sense. And in that case, there are a number of items of loss that Accenture was saying, look, we think these are indirect and consequential losses. They're covered by this part of our standard terms saying we exclude liability. And the court said, no, you mustn't forget that the key test here, any loss which directly flows from your breach is going to be a direct loss. And normally that will allow some recovery, albeit it may be quite modest. So a lot of the losses that I think would happen from a cloud computing contract anyway, in relation to data loss, etc., would be direct loss rather than indirect and consequential loss. And so you don't have both hands tied behind your back. The only trouble is because you've also got the express exclusion of liability in many cases for direct loss and destruction, you've then got the secondary battle to say, well, actually that express loss, it's happened, although we've agreed up front that it should be covered, is that so unreasonable that it should be held to be invalid? But anyway, GB Gas Holdings is a good case for just reminding you that not all loss that you might think is not all loss which is just consequential is actually consequential loss in a legal sense. It may well be direct loss, hence you can recover some of it. Some final thoughts on where we are at the moment, really. As I think really echoing some of the earlier comments, although Mimecast's been going for a decade, so that makes them one of the early players in this field, and so they might disagree, I suppose, my next comment, but certainly in terms of legal terms, I would say that cloud computing contracts are still relatively immature in that there's quite a bit of variety between providers on different areas, whether it's data protection issues, whether it's disclosing data to law enforcement areas, and also sometimes limitations of liability as well. So the market is still immature. It's certainly true that bigger public sector organisations in the US and the UK have anecdotally managed to negotiate quite significant amendments to what would otherwise be standard terms. But of course, I can't deny what Mark said, that for a lot of SMEs, up until a certain size, you're going to have very little bargaining power whatsoever. So it does pay, if you can, to actually shop around because they're not all cast in stone. So there is some variety from provider to provider, although there are still generally pro-provider, which you won't be surprised. Where deals are carried out on standard terms, it is also worth bearing in mind under the English legal principles that the Unfair Contract Terms Act may apply. So where there is a serious loss and you're looking for a remedy, there may be scope for challenging some of the limitation clauses, and I've touched on that already. One key thing, probably I should put it earlier in this slide, is, of course, even if you have a good ding-dong battle and get good amendments to the standard terms, which you're happy with, do you need to look out for a couple of small things. One thing, which is a bit insidious, is quite a few providers have terms basically saying that they can unilaterally vary the terms on giving notice at some point, 30 days, 60 days, 90 days. So that's a bit like saying, well, we can agree today. I give the concession today, but in 3 months' time, I'm going to unilaterally change the contract. And typically in those contracts, the way of doing that is really just posting an amendment on the relevant website, etc. So that's one of those variations which I think should be strongly resisted because it will undo all the good work in negotiation stage. But moving on, the corollary is if you can't get rid of the actual right itself, the next best thing really most users can do is to make sure there is an express right to terminate the agreement if obviously something really quite significant is amended halfway through the contract. So there are various ways, hopefully avoiding it would be best, but if not that, at least the right to terminate the agreement itself. Although, of course, that's a long way back and a much less preferred option, I think. Yeah, data issues. We had a lot of discussion about the fact that we've got so many different laws in the UK, the US, and all the practice and the rest of it. It's interesting because on one or two recent articles I've read about this whole area, one or two writers, I think it was the head of legal at Microsoft UK, was pointing out the fact that under the Data Protection Act, Directive, I think it is, Article 27, there's already sort of a mechanism or references to member states trying to encourage codes of practice. So, I mean, there's nothing, I think, that may stop codes of practice evolving, at least to try and get agreement within the EEA as to the sorts of data protection issues that should be expressly set out in contracts. And a bit more ambitiously, but I've also seen it, expressed that the hope, I think probably the hope more than expectation, that we might be moving at some point to some global harmonised data protection rules. Given the way these things, I think the problems we've had with 25, obviously EU member states, a global harmonisation might be a step too far, but there are existing mechanisms within data protection legislation in Europe to actually try to encourage greater consistency across the trade and across the sector and across the geography of the EU. And that's an emerging area which may or may not happen. That's all I wanted to say, really, given that I think otherwise we might be going over ground already in relation to data security issues, but more than happy to take some questions on the areas I've covered.